A pleasant day everyone, I am Zenaida Bantilan and today we're going to discuss about the chapter 7 of our legal aspect in tourism hospitality, which is the laws regulating transportation establishment. Our learning objectives are: first is to identify the laws affecting the transportation sectors. Second is to identify the rights of passengers of commercial transportation. And lastly is to explain the relevance of these laws to the promotion of tourism in the country. The Philippines has become one of the promising tourist destinations due to the extraordinary hospitality of the Filipinos and the diversity of tourist attractions in the country. However, one challenging aspect of promoting inbound tourism in the Philippines is the security and safety issue. The transportation sector is therefore greatly affected by this concern. On one hand, some of the best transportation and travel professionals are Filipinos, and on the other hand, some of the worst recorded transportation disaster and accidents are happened in the Philippines. The civil codes define common carrier in the following term. In Article 1732, common carriers are persons, corporations, firms or associations engaged in the business of carrying or transporting passengers or goods or both by land, water, or air for compensation, offering their services to the public. So, a common carrier is for the public usage. On the other hand, a private carrier is not in the business of transporting public employment. Based on Article 1733, Article 1755, Article 1756, and Article 1757, as soon as the passenger puts his foot on the platform, the obligation of extraordinary diligence of the common carrier begins. The relation of carrier and passenger does not cease at the moment the passenger aligns forms the carrier's vehicle at a place selected by the carrier at the point of destination, but continues until the passenger has had a reasonable time or reasonable opportunity to leave the carrier's premises. A certificate of public convenience is not a requirement in order for a common carrier to incur liability. Such liability arises from the moment a person or firm acts as a common carrier without regards to whether or not such carrier has been granted a certificate of public convenience or has complied with the requirements of the applicable employment regulation. The term extraordinary diligence has been defined as the standard of care required of common carrier bringing safety its passenger or at goods from one place to another. In a contract of carriage of passenger, it is the obligation of the common carrier to bring the passenger safely to the point of destination. If injured or death occurred, the presumption of negligence automatically arises and the common carrier can be held liable if he fails to prove extraordinary diligence for the duration of the carriage. Liabilities of common carriers for the acts of employees and strangers. According to Article 1759, a common carriers are liable for the death of or injuries to passengers through the negligence or willful act of the former's employees, although such employees may have acted beyond the scope of the authority or in violation of the orders of the common carriers. These liabilities of the common carriers does not cease upon proof that they exercise all the diligence of a good father of a family in the selection and supervision of their employees. For the bus company, due negligence in the selection of employees is just satisfied by finding the applicant possessed a professional driver's license. The employer should also examine the applicant for his qualification, experiences, and record of service. Due diligence in supervision, on the other hand, requires the formulation of rules and regulations for the guidance of the employees and issuance of proper instruction as well as actual implementation of monitoring of consistent compliance with the rules. For a shipping company, the vessel must be considered seaworthy, adequately equipped for the voyage, and manned with a sufficient number of competent officers and crew. Enforcement of liabilities of common carrier. The liabilities of common carrier can be enforced on the following causes of action. First is, in case of death or injury caused to passengers, the victim may file a case of breach of contract of carriage or culpa contractual against the owner of the common carrier. Second is that in case of death or injury caused by a stranger or pedestrian, the victim may file a criminal complaint against the driver of the common carrier for reckless imprudence resulting in homicide and damage to property. The victim may also file a civil suit against the common carrier and its driver on the ground of culpa aquiliana or quasi-dialect is recoverable from common carriers. In an action based on culpa contractual or culpa aquiliana, the damages that are recoverable are first are the actual damages, compensatory damages, moral damages, exemplary damages, death indemnity, and attorney's fee. Nominal damage may be awarded in case of moral or exemplary damages may be not be awarded. The nature of airline, bus, and shipping tickets. The best evidence of a contract of carriage is the passage ticket. Under our jurisprudence, an airline, bus, or shipping ticket is a contract of adhesion considering all provisions thereof are prepared and drafted only by the carrier. The only participation left of the other party is to affix his signature thereto. In such situation, the Supreme Court ruled that the terms thereof must be interpreted against the party who drafted the same, in this case, the carrier. Registration of aircraft. Only aircraft owned by or leased to a citizen or citizen of the Philippines and which are not registered under the law of any foreign country may be eligible for registration. The certificate of registration is conclusive evidence of ownership, except in a proceeding where such ownership is in the issue or when the aircraft is only under lease. Regulation of the shipping industry. The Maritime Industry Authority, or MARINA, was created on June 1, 1974 with the issuance of the Presidential Decree Number 474 to integrate the development, promotion, and regulation of the maritime industry in the country and in the regulation of the land transportation. Today, it is the Transportation Office or LTO and the Land Transportation Franchising and Regulatory Board or LTFRB, which are the agencies involved in the regulation of the land transportation industry. Seatbelt Law. Republic Act 8750 mandates the installation and use of adult seats belt in the front and rear seats of any private motor vehicle. The purpose of the seatbelt law in the Philippines is to reduce the chances of death and injuries from road crashes. This law also banned children 6 years and younger from occupying the front seat of any vehicle while a running engine even if the child is wearing seatbelt as stated in Section 5. Law on Transportation of Animals. By virtue of Republic Act 848565, also known as the Animal Welfare Act of 1997, it shall be the duty of any owner or operator of any land, air, or water public utility transporting pets, wildlife, and all other animals to be provided in all cases adequate clean and sanitary facilities for the safe conveyance and delivery thereof to their consignee at the place of consignment. This animal shall be provided with sufficient food and water while in transit for more than 12 hours or whenever necessary. No public utility shall transport any such animal without a written permit from the director of the Bureau of Animal Industry or his or her authorized representative. Importation of vehicle. There are relevant laws on the importation of vehicles which may be useful for the transportation businesses. Namely, first is the Republic Act 7227 which allows the free flow of goods and capital within the Freeport in Subic, province of Zambales in order to attract investors to invest their capital in a business climate with the least government intervention. Also, there are President Arroyo's Executive Order 156 which prohibits the importation of used motor vehicle into the country. Under the Philippine Clean Air Act of 1999, any imported, new or locally assembled new motor vehicle shall not be registered at the LTO unless it complies with the emission standards set as evidenced by the Certificate of Conformity by the Department of Environment and Natural Resources. Also, under the Republic Act number 8750 or known as the Seatbelt Used Act of 1999, it shall be unlawful for any person to import or cause the importation of any vehicle without appropriate and operational seatbelt devices. Public service laws. Public service includes every person who may own, operate, manage, or control in the Philippines for hire or compensation with general or limited clientele, whether permanent, occasional, or accidental, and done for the general business purposes. Any common carrier, railroad, or street railways, transaction railway, subway, motor vehicle, steamboat, or steamship line, ferries, and watercraft and shipyard. Unless otherwise exempt, no public service shall operate without having been issued a certificate of public convenience or certificate of public convenience and necessity. Traffic law. The most comprehensive law on driving and traffic regulation is our Republic Act 4136, otherwise known as the Land Transportation and Traffic Code, which was enacted way back in 1964. This law created our Land Transportation Office (LTO) and provided all the groundwork for almost all of our traffic regulations today. Republic Act 4136 required, among others, the first is the registration of all motor vehicles and second is the application of all drivers for either a professional or non-professional license. The law likewise set the corresponding penalties for failure to comply with the registration and licensing requirements, which penalties were updated every now and then by the LTO.